Good evening, everybody. Good evening. Akash, it's already uploaded. You may have not checked yet. We finished with Article 19 and 14, 19 and 21 in Menka Gandhi yesterday. We are going to spend some time discussing Article 20 and 22 at the moment. So let us spend some time on Articles 20 and 22. Now, what we're going to be doing as far as these articles are concerned is we're going to first spend some time and we're going to figure out what is it that they're referring to. Okay, we're going to get some background concepts clear, get some basic understanding of the criminal justice system in India, and apply the same principles to Articles 20 and 22. Now, we follow the same concept of broad versus narrow, where Article 20 refers to certain general principles, with respect to justice, and Article 22 refers to two parts. First is arrest, that is after an incident has happened, and second is to prevent an incident from happening, therefore arresting somebody beforehand. Now that is called preventive detention. We are going to get into the technicalities here, but before we get into the technicalities, let us spend some time on understanding the broad concepts of the criminal justice system. That will automatically make your life a little bit easier. So, let us start. We're going to understand the broad contours of the criminal justice system. Now, there are some basic terminologies that are used that we have to first get right. The first word that we understand with respect to the criminal justice system is the word called criminology. The first word is called criminology. Now, criminology is often considered a subset of sociological study wherein you're trying to figure out as to why do crimes happen, why does society adapt to crime, what are the reasons as to why somebody can commit a crime, and what could be your appropriate way to stop the crime. So, criminology contains two basic theories. First is the theory of crime, and second, you also have the theory of punishment. Some of you may have heard of this person called Edwin Sutherland. Edwin Sutherland is a very well-known sociologist and a criminologist who has given some fantastic theories of punishment which also get applied to understanding modern day punishments. So for example, he refers to, say, punishments have to fulfill certain reasons such as creating deterrence, right? That the punishment is to prevent other people from committing the same crime, thereby creating a fear of the law. That's the first part. Second is punishments often have to be reformative in nature. The person who's been awarded the punishment, the person who is undergoing punishment, that person after undergoing punishment would be a reformed individual and therefore will not look at committing the same crime. Third is you often have something called a rehabilitative theory, wherein you are trying to undo the damage which has been caused by the person who may have committed the crime. Okay, so this is the first word that we must understand. This is a theoretical word, this is a study, this is an academic discipline which is also called criminology, which looks at the theory of crime and of course the theory of punishments. Now, the reason I have mentioned these three theories to you is because more often than not, when you are arguing death penalty in India, these are the three grounds on which you can often argue for and against death penalty. That we have death penalty in India for some very serious crimes, for some extremely heinous crimes, and does that necessarily create a fear of the law? Is it truly reformative in nature? And does it undo the damage which has been caused by the criminal? So this is a word called criminology. Then you have something called criminal law. Then you have something called criminal law. Now, criminal law has two elements to it. One is your substantive criminal law, and second is your procedural criminal law. Your substantive criminal law works on a very simple principle, which basically tells you what is a crime and what is the punishment for that crime. Right? Now you can have general substantive laws, you can have specific substantive laws, and so on and so forth. Like for example, the Indian Penal Code is India's largest substantive criminal law, dates back to 1860 and is a British legislation. And one of the criticisms is that it hasn't been updated to accommodate modern day changes. And it basically contains a list of crimes, and it contains what is called the punishments for it. And then you also have procedural criminal laws, for example CRPC, the Criminal Procedure Code. This basically explains to you how will the state proceed, or what are the procedures that you have to follow with respect to the investigation of the crime, with respect to the intervention of the state judicially with respect to the crime. So, for example, where should an FIR be filed? When should an FIR be filed? How should an FIR be filed? What kind of documents are needed in the court? Then you also have, evidence acts. You have, interpretation acts, and so on and so forth. So, this is basically what is called criminal law. Now, your criminal justice system will usually comprise of these two. Nowadays, there is a new and an upcoming branch called victimology. Victimology is the study of crimes from the victim's perspective, figuring out why is this particular person, or why is this type of a person being targeted for a crime that is being committed against the person. This is also used in investigation in a lot of developed countries of the world, wherein you are trying to profile the criminal through the victim of a specific crime. So these are basically what are called your backgrounds to the criminal justice system. Then we must also understand that the fundamentals to the criminal justice system, some basic concepts. First is the application of checks and balances, right? Which is nothing but rule number 4. Which is nothing but rule number 4. So let's understand what is it that we are referring to. See, the legislature has made a criminal law. The executive is supposed to enforce the criminal law and take action when the law is being violated. And that is why it is the judiciary who should decide whether the crime happened or not, and whether what should an appropriate judgment be. So the judiciary is the one who decides, or is the person who finally decides on the outcome of the crime. This is done because of a simple application of what is called rule number 4, which we studied in our earlier classes, called checks and balances. So that's the first basic concept. The second concept that we often understand is that India is a common law country, and we've discussed the word common before. For instance, Commonwealth. So Commonwealth is basically a bunch of countries who have been erstwhile British colonies. Similarly, common law is a legal system which is prevalent across all erstwhile British colonies. It is a legal system which is present across all erstwhile British colonies. Okay, now let's understand this as well as we can, as clearly as we can. So, one of the principles of common law when it comes to criminal law is that a crime is committed due to the failure of the state. Due to the failure of the state. So, therefore, the crime is actually committed against the state. So, it does not necessarily mean that the victim has to, the case has to be proceeded in the name of the victim. That's not necessary, which is why you will see a lot of criminal cases are and because law and order is a state subject. So, for example, state of UP versus X. So, X will be the person who is allegedly has committed the crime, and when this goes on appeal, it will be X versus state of UP. So, this is commonly how you see criminal cases being represented in a court. Now, the reason why this happens in India is because India follows what is called a common law system. Now, from a theoretical point of view, what constitutes a crime, right? What are the ingredients of a crime? Now, for general studies students, this is more than enough. Law optional will of course get into a lot of technical detail behind this, but for general students, general studies, this is more than enough. As far as the ingredients is concerned, we use two Latin words. One is called mens rea and the second is called actus reus. Mens rea and actus reus. See, mens rea is the intention to commit a crime, is the intention or the motive to commit a crime, and actus reus is the actual act or the actual execution of the crime. Now, in some cases, the mental intention or the motive is enough. In some rare cases, the act speaks for itself. But generally, usually, to prove that a crime has been committed by a person, you have to prove two things. One is mens rea, the other is actus reus. Now, let's look at the fourth concept here. The fourth concept here is there are certain kinds of criminal offences. There are certain types of criminal offences. Now, you just need to know the basics of it. You don't need to know anything else. So, what are the types? The first is cognizable. The first is cognizable slash non-cognizable. Okay. The first is cognizable slash non-cognizable. The second is bailable slash non-bailable. Okay. The third is compoundable slash non-compoundable. So these are basically the types of criminal offenses. So a cognizable criminal offense is where the police can arrest without a warrant, usually for serious cases. Every crime will have mentioned whether it's a cognizable offense or not. A non-cognizable offense is where the police cannot arrest without an arrest warrant. Okay? So relatively serious offenses are cognizable in nature. A bailable offense is where the court can grant you bail. Bail can be granted. Bail is while your criminal case is in proceeding and the court is in progress at the court, and you are in jail, you have been sentenced to, or you are kept in custody, or you are in jail while the case is going on. You can request the court to grant you a bail, that I'm here only, I'm not going to leave town, I'm not going to leave the country, I will keep showing up to the police station every week, or I will always be there whenever my next hearing happens. So please let me be at home as far as the proceeds of the case is concerned. And in some cases, bail cannot be granted. So obviously, serious offences, you have non-bailable offences, and non-serious offences again depends on the kind of offence, they will usually be bailable offences. Now when we look at compoundable and non-compoundable offences, what is it that we understand? A compoundable offence is where you can, now despite the fact that a crime is against the state, but certain crimes can be settled outside court. Certain crimes can be settled outside court, and certain crimes cannot be settled outside court. Okay? So you've got compoundable and non-compoundable offenses. Like for example, matrimonial crimes are compoundable offenses. So if the husband and the wife have come to an arrangement, have come to a mutually agreeable conclusion, then whoever has filed a criminal case can withdraw that criminal case. But in murder, in rape, you can't do that. These are non-compoundable offenses. So for example, let us say rape. The offense of rape is a cognizable, non-bailable, non-compoundable offense. So you have different combinations with respect to each crime. So these are the basic types of criminal offenses. These are the ones that usually exist in the country. Okay? Every offense, either in the law itself or in a procedural law, will mention the nature of the offense and the process behind it. And that's largely how it is run. Now that we've understood this, let us spend some time and let's figure out the journey of a crime. Okay? Once we understand the journey of the crime, we will be able to understand how Articles 20 and 22 can play a role. Okay? So let's get this right. So we are looking at the journey of a crime. Okay. The first part of it is the commission of the crime. The first part is the commission of the crime, where the crime is taking place. Now, there will always be at least two people. One will be the victim, and the second is going to be the perpetrator. the victim and the perpetrator. Now, sometimes there may be witnesses. Okay? This happens in a physical space, or this happens in a space, and that is called a crime scene. So nowadays, with respect to cyber crimes, the very idea and the definition of crime scene has become extremely fluid. Okay? Now, this is how a crime has been committed. The crime would have been committed in a specific geographical area, at a specific place. Now, depending on the nature of the crime, in some crimes you can only file an FIR in the nearest police station or file a complaint in the nearest police station. In some cases, you can file the FIR or the complaint anywhere you want. Now, I'll come to what is an FIR and what is a complaint in just a bit. But this is the first stage where the crime has been committed. Now, once the crime has been committed, now comes the second stage, which is the reporting of the crime. Comes the second stage, which is the reporting of the crime. Now, what is the reporting of the crime? Very simple. It is that either the victim, if the victim is alive, reaches the police station and informs the police, or if it is a crime where the victim is no longer alive, the police has discovered the body and has taken this crime into cognizance that, okay, we have formally recognized that a crime has been committed. Now, this is where a large problem in India arises, wherein a lot of the crimes go unreported. So, for example, when we look at the statistics that are often released by the National Crime Records Bureau, those statistics aren't particularly accurate because they discount the fact that a lot of the crimes are not even registered at the police stations, or the people are hesitant to come to a police station and disclose the fact that a crime has been committed against them. Anyways, so now a crime has been committed, the crime has to be officially recorded, right? The crime has to be officially recorded. Now, the usual cycle is when you reach the police station, you will meet an officer. That officer will become the investigating officer, the IO, right? Now you will tell the IO XYZ has happened. The IO will draft a criminal complaint, take a note of everything and give you a copy of the criminal complaint, right? Of course, reality might be different. We're not getting into it, but I'm talking about the law. Then the IO is going to perform a preliminary investigation and find out whether there was a genuine crime or not, and on the basis of it, the IO can register an FIR. Now, in some serious crimes, you bypass this process and you have to directly file an FIR. There is no option. You have to necessarily file an FIR. So, what makes an FIR so special? What makes an FIR so special is that once an FIR has been registered, this means the case will necessarily go to court for trial unless the victim is withdrawing the case. Otherwise, the case will necessarily go to court. The only people who can quash an FIR are the high courts and on appeal the Supreme Court. Otherwise, you can't quash an FIR, you can't cancel an FIR. This is also why the police are often hesitant in drafting or filing an FIR, because once an FIR has been registered, then the police must have to take action on the complaint that they have received. Now what happens is, when a lot of times when the police is just drafting a criminal complaint, they can sometimes come to a conclusion that there was no genuine crime, and they can quash the complaint there itself. They can stop the proceedings there itself. But once an FIR has been filed, it stands for First Investigation Report. It must be necessarily taken action upon. This is broadly the element of reporting. Now that this has happened, you start with the third phase of it all, which is called investigation of a crime. Okay, the investigation of a crime. Now, in investigation, you primarily have two things to do. First, you have to identify your suspects. Second, you need to identify your witness. And third, you need some form of evidence, right? Some form of evidence. Now, the police is in the process of all of these three elements of investigation. This is where the police can call people for questioning, the police can arrest somebody on the basis of certain evidence, and so on and so forth. And this is where, when the police is arresting somebody on the basis of some witness or some evidence or some credible suspicion, then you will see that some of the provisions of Article 22 will kick in, wherein basically the police has performed their executive action by implementing a law. Once the police has arrested somebody, within 24 hours, you have to present the person before a judicial magistrate. Okay, and travel time and public holidays are not counted in these 24 hours. Only if the judicial magistrate agrees that yes, this person should be in custody, then is only when you can keep the person for more than 24 hours. Now, the judicial magistrate can give two kinds of custodies. Okay, first is what is called a police custody, and the second is what is called a judicial custody. The difference is the time and the tenure of the judicial custody is always more than the police custody. Police custody would be 7 days, maximum 15 days. But judicial custody can even go for 3 weeks, 4 weeks also at a stretch. The second is, when somebody is placed under judicial custody, that means the judiciary has ordered for their detention. So they will not be kept in an ordinary jail, they will be kept in a special jail, and the police cannot investigate or cannot interrogate without the permission of the judiciary. This is nothing but an application of rule number 3, which is separation of powers, because it is the judiciary who has given this kind of an order. Okay, now this is usually what happens. They collect the suspects and they collect their evidences, they collect their witnesses. Now, what basically happens here is, you are able to determine a few things, that there is going to be somebody called a prime accused, somebody who you think has committed the crime as per the police. Or you may think that there is no accused, we could not find anybody. There will always be somebody called a prime witness, that this person has witnessed the crime or has some credible information. And then you also have your substantive evidences. Now, there are different forms of evidences: circumstantial evidence, corroborative evidence, substantive evidence. This has been in the discussion in the news largely due to the marital rape debate, which has been in the news. But for general studies students, you don't need to know the types of evidences and so on and so forth. Law students should definitely have an idea with respect to this. Okay. Now, we are absolutely clear on this. We are absolutely sort on this. Now that this investigation stage is going to come to an end, right? What is going to be the outcome of the investigation? The outcome of the investigation is either the police will have the necessary evidence and the accused and the witness, or they will not. If they do, then they will file what is called a charge sheet in the criminal court. If they don't, then they will file what is called a closure report. They'll go to the judge and say, we did not find any reliable evidence, we are not able to investigate the crime, so please dismiss the crime, please dismiss the case, we've run out of capacity, right? This is how it is done. Now the case reaches the court. This is where it gets very interesting. Okay. Now the case reaches a criminal court. Now we've understood that all criminal cases or most criminal cases is the state versus the accused, right? It is the state versus the accused. This part of the state, which means you are being tried for a crime, the government wants you to suffer from the best form of punishment appropriate for you in the context of the crime. This is called prosecution. This is called prosecution. Okay? And this is called defense. This is called defense. Now, because this is the government, so you're going to have a government lawyer, and that government lawyer is called a public prosecutor, and the government lawyer is called a public prosecutor. A public prosecutor is nothing but a government sanctioned criminal lawyer. That is it. And here, of course, you have a defense counsel. Okay, counsel is C-O-U-N-S-E-L, not C-O-U-N-C-I-L. Okay, now the case is before the court. The police is of course going to assist the prosecution with all the evidences that they can. There are certain rules, there are certain procedures that have to be followed, and so on and so forth, right? Now, while all of this happens, the accused can appeal for bail, that while the case is going on, please let me go home, or in some cases the person has to be in jail. If the person is in jail while the case is going on, then this person is called an under trial. Then this person is called an under trial. And the sad state of Indian prisons is that most of the people who are in Indian jails are actually those against whom cases are currently going on. More than half of the prisoners in India are actually under trials. Now you see, there are some very interesting concepts that get applied to criminal law. The concepts are, first, something called burden of proof. Burden of proof. So let us say the accused is A. There are two kinds of burden of proof. One is that the prosecution has to prove that A has committed the crime. That's the first kind of burden of proof. The second kind of burden of proof is that the defense has to prove that A has not committed a crime. Now, this in simple English also translates into some very commonly heard words. This is called innocent until proven guilty. Innocent until proven guilty. And this is called guilty until proven innocent. Guilty until proven innocent. Okay? Now, Sami, this is a very serious thing, and please don't expect the teacher to sing and dance and jump all the time. Please understand that sometimes I may also not be feeling well, or I may also be slightly unwell, so please respect that a little bit. चलिए, ये समझ में आ रहा है? Clear? So here the prosecution has a more difficult job. They have to prove that A has committed a crime. And here the defense has to prove that A has not committed a crime. The defense has to prove that A has not committed a crime. That means here it is more difficult on the defense. So in the first case, the burden of proof is on the prosecution. In the second case, the burden of proof is on the defense. For some very serious cases, such as rape, the burden of proof lies on the defense. If somebody has committed rape, it is assumed under the law that A has committed rape. It is assumed under the law that A has committed rape, and A has to prove that A hasn't committed rape. Okay? Understood this? Clear? Right? Okay. Now that we've understood this, now that we get this part right, let's get down to the next parts of it. Now that we get the whole burden of proof discussion right, we come to the next part. There are basically two outcomes. Either based on evidence and witnesses, the court will find the accused guilty, or you will find the person not guilty. Another word for not guilty is acquitted. Okay? Another word for not guilty is acquitted. And another word for guilty is convicted. Another word for guilty is convicted. Okay? Once you have been convicted, then you will be sentenced to a punishment, which basically means you will either have to pay a fine or go to jail or do both. So this is basically the journey of a crime. Now in this entire journey, you see the police is going to meet you, interact with you, cases are going to run against you. So what are the kind of protections that exist as far as an individual is concerned with respect to your general justice system? Okay, this is largely what the whole point of this discussion was. Samir, I hope you understand that I wanted to keep it extremely simple. I wanted to keep it like a story so that people understand, है ना. इन चीज़ों का मजाक नहीं उड़ाते हैं because ये बहुत sensitive चीज़ें हैं, right? So you will never see me joke about anything which has the word rape in it, because I have seen rape victims. I have seen what happens to people when they get raped. So it is something that I will never be able to, if I'm talking about it even in the most unrelated context, I will always maintain the sanctity of it. Anyways, so let's get this right. Now, where are India's general criminal justice problems? Of course, there is a pendency, the quality of public prosecutors is very poor, and this is something we don't pay enough attention to. For example, and this is somewhere very reflective of the feudal mindset of our country, wherein the police seems to be, the the holder of power, the custodian of power. We see a lot of this, we see a lot of brute power and brute force which is exercised in the name of the police. But if you really understand, it is this public prosecutor who is responsible for arguing well enough, fighting the case well enough to make sure that there is no stone unturned, so that the accused is guilty, proven guilty, convicted, and then sentenced. Now, the problem here is we don't have a very good talent pool. The best people from best law schools, good people don't come here. The second issue here is that they are not given the right kind of support. They don't get enough clerical staff, stenographical staff, research staff. They don't even get security when they're handling such high profile criminal cases. They do not get the right kind of benefits, and therefore they're overburdened with cases, so they're not able to qualitatively deal with cases. Let me give you an example of how glorious this job is. Some of you may have seen a movie called Batman. In Batman, there was a fictional character called Harvey Dent. Who was Harvey Dent? Harvey Dent was basically a public prosecutor. And just see the kind of image, the power, the status, the kind of influence this person had. In the US, public prosecution or public prosecutors is like a stepping stone to an active career in politics. But in India, often the bureaucracy is a stepping stone to an active career in politics. So that sort of makes you understand, makes you understand sort of the depth of cases. Look at Ankit, who's asking such an insensitive and such an insulting question. Sir, how many cases have you won till date? Just asking. I have won the same number of cases in the same number of times you have won a gold medal in your life. ठीक है, same number of times. ऐसे कौन पूछता है? Of course, I've won majority of the cases so far. And it is never just about winning or losing, because lawyering in India is very adversarial in nature, and that's one of the fundamental problems there. And let me give you an ethical perspective here. Okay, let me give you an ethical perspective. The public prosecutor has to do everything that the public prosecutor can to put A behind jail. And the defense counsel here has to do everything the person can to represent the best interest. Now, if the person knows that A has committed the crime, then there's an ethical conflict. Our legal system has been designed in such a way that it is adversarial in nature, that it will always be X versus Y, there will always be a fight, somebody has to win or lose. You must understand, whether it is a public prosecutor or a defense counsel, both of them are officers of the court. Whatever is in the best interest of justice must be done. But on one hand, you have the interest of justice, and on the other hand, you have an obligation to represent your client to the best of your capacity. Now, such a beautiful ethical conflict to quote in your paper 4, to quote in your answers, to give a lot of depth. So this is a problem. Another problem is the quality of our lower judicial judges, which is also one of the reasons why All India Judicial Services make sense. Today, people from IITs, IIMs, DU, etc., fight the battle to get into the civil services, because it's an All India service, it's nationally coveted. If we did not have an IAS or an IPS, we just had state services, then perhaps we would not see so many students from such bright colleges across the country pursuing a career in bureaucracy. When you have an all India service, it automatically adds a lot of prestige to your job, a national coveted stature to your job. Okay, understood this? So that is the case. An under trial is somebody who's in custody while the case is going on. That's it. So these are the broad ideas. We'll do, of course, criminal justice in detail when we do justice and judiciary later after the parliament and everything else. But this is the larger context. This is how the criminal justice system in India is largely executed, is largely institutionalized. Okay, now let's understand this from the perspective of Article 20 and 22. You can take a 5-minute break. Then we'll start with Article 20 and 22, because I can understand this would have been a lot of information for you to consume. So take a quick 5-minute break, and then we'll pick up Article 20 and 22. In the meantime, I will recommend that you at least read Article 20 first before I come. Yeah. No, Harsh. Thank you, Rupesh. No, Ankit. So, let us look at Article 20. The title for Article 20 is Protection with respect to conviction for offences. It has three subclauses. The first subclause, no person, which means this is available for citizens as well as foreigners, shall be convicted of any offence. No person shall be convicted of any offence except for a violation of law in force at the time of the commission of the act, charged as an offence, nor be subjected to a penalty greater which may have been inflicted under the law in force at the time of commission of an offence. Okay. Now, let's understand this. This I will discuss by writing it on the board. This basically refers to a concept called retrospective application of the law. Retrospective application of the law. Okay. Now, this is the first concept that we've understood. Now look at Article 20, Clause 2. Again, no person, which means available to citizens and foreigners both, shall be prosecuted and punished for the same offence more than twice. This refers to the principle of double jeopardy. Okay, I will talk about this in the next few minutes. Third, no person accused of any offence shall be compelled to be a witness against himself. This is the right against self-incrimination, which also has a relationship with the principles of natural justice, which we had discussed yesterday. So these are the three basic concepts that come to light when we try and study Article 20. Okay, now let us start. When we look at Article 20, the first concept that we are referring to is retrospective application of the law. Retrospective application of the law. Okay. Now, retrospective means from a back date. And law here means only criminal law. It does not mean civil law. Let me teach you this with an example. Okay. The example that I'm going to give you is of the Delhi Nirbhaya gang rape incident. Okay. The Nirbhaya gang rape incident. This was not the real name of the person. This was a name which was given as a sign of courage, as a sign of determination, and also to protect the identity of the person involved. Now, some of you, and I'm sure most of you, would remember the graphic details of what happened. On a cold December evening in Delhi, a girl accompanied by a boy who had boarded a bus were gang raped on the bus by a bunch of men, right? And not only gang raped, but also assaulted to the point that the girl eventually lost her life because of the sheer brutality of the way it happened. Okay. Now, we have a law. So this happened on a specific date. and only the law of that date will be applicable on the incident. Only the law which is in force on that date will be applicable on the incident. Now understand, one of the people who had committed gang rape was a minor, which means the person was below 18 years of age. And when this crime was committed, there was a provision in a law called Juvenile Justice Act. Juvenile is basically child criminals, okay? Juvenile Justice Act. And the provision said minors cannot be treated in the same way as adults for crimes. This was in line with the reformative theory of punishment, that children are capable of recovering to decency and a righteous way of life. Now, this minor who had participated in this gruesome and unimaginable event would not be treated the same way as an adult would. Okay? This means the defense would put all the blame on the minor, and the minor would get some juvenile detention for a few months or a few years and would be let out. And the minor will confess that I was the one who did everything, nobody else did anything, and everybody else will be set free. This caused national outrage in the country. That I understand that children and adults should not be treated the same way, but this is not an ordinary crime. If a child can think of doing something like this, then I'm very sorry to say that the child is incapable of reform. This is not the mind of a child. This is not the innocence of a child. No amount of reform can reinstate morality back to the child. And there were several movements, there were several protests, as a result of which the government had set up the Justice Verma Commission, which gave a lot of recommendations on making laws safer for women. One of those was also with respect to marital rape, but it also spoke of how for serious crimes, minors should be treated the same way as adults. Now, this change that happened to the Juvenile Justice Act happened after the incident. The minor here would still be charged with the provisions here. These provisions will be applicable to the minor, not these provisions, because this is the law on that date. You cannot apply this provision on a back date. This is what is called retrospective application of the law. It simply means that for somebody to be charged with the crime and the punishment, you can only be charging the person with what the crime was and what the punishment was the day the crime was committed. You can't make a law tomorrow and say, oh, that was a crime and now we're putting you in jail. If it wasn't the crime when you committed it, nothing is going to happen to you. This is applicable only to criminal law. But you can retrospectively apply civil law, because civil law does not compromise life and liberty. For example, you would have all heard of something called retrospective taxation, which was recalled by the government last year, and the Vodafone case was a startling example of the same. Similarly, when you get into civil services, you're also entitled to something called pay commissions, which revise your salaries every few years. And sometimes the pay commissions get delayed. and the increase in your salaries are applied from a back date, and that is how you earn arrears in your salary. So, civil law, perfectly fine. Criminal law, no. This is what is called retrospective application of the law. For a person to be charged with a crime, it should be a crime on that day, and only the extent to which it is a crime will the person be charged with. Otherwise, it violates principles of natural justice. It's an unfair trial. Why will you send somebody to jail or give a punishment which did not exist when that particular incident happened? Okay, when that particular incident happened. So this is what is called Article 20. Okay, and this is largely what we are referring to. All right. Now that we've understood this, now that we've gotten this part right, let's move to the next concept. The next concept is the principle of double jeopardy. The principle of double jeopardy. The principle of double jeopardy states very clearly that a person can only be given one punishment for a specific crime. For a specific crime. A person can't be convicted and punished twice for the same crime. Very interesting. Let's understand this in the context of some practical implications, right? Let us say there is a person A, okay? The person A is driving a car. I'll give you two scenarios. Scenario 1, person A is driving a car without a seat belt, okay? Is driving. First signal comes, the cop catches the person, issues a challan. The person pays the fine, carries on. Is again a very obstinate kind of a person, still doesn't wear a seat belt. Drives, reaches signal 2. Another cop catches the person again, issues the second challan. Now the person says, I am Mathur sir's student and I have the principle of double jeopardy with me. You can't issue me a second challan. The cop says, don't worry, I am also Mathur sir's student and he taught me that these are two separate crimes. These are two separate crimes, and that is why I'm going to give you a second challan. Your traffic challans will always have the time period for how long the challan is valid. Okay, so this is how it works. Like for example, Delhi had this odd even scheme, right? Odd even scheme. So let us say there was a person who was driving their car, an even number car on an odd day, and the cop caught the person. The cop issued a challan. Now that challan is valid for the whole day. The person cannot be again challaned by the second cop just because the person has been caught. This challan is valid for the whole day, right? So here principle of double jeopardy will apply. A more practical example of the principle of double jeopardy is this. It applies a lot to under trials. Now, who are under trials? Under trials are people in prison who have been denied bail and their case is currently going on. Okay. Now, let us say there is a person A. This person, let us say in 2022, committed a crime called kidnapping. Committed a crime called kidnapping. Okay. Now, there is a difference between the word kidnapping and abduction. Okay. There's a difference between the word kidnapping and abduction. Okay. You kidnap children and you abduct adults. So this person was charged with kidnapping, was caught in time, and so on and so forth. Now what happens here is something very, very simple, something very interesting. This person's bail has been denied and this person is in jail for very long. Let us say this person has been in jail for 10 years. The maximum punishment, let us assume, for kidnapping, let us say, is 7 years. The maximum punishment for kidnapping is 7 years. Okay. Now, after 10 years, in 2032, after 10 years, in 2032, the court says, the court convicts this person, says, you are guilty of kidnapping and we are going to send you to 7 years of jail. Then A will immediately inform the court, what 7 years? I have already spent 10 years in jail. I have given you 3 years of bonus. Okay, I have given you 3 years of bonus, which basically means that I have already fulfilled the maximum punishment. So under the principle of double jeopardy, you cannot send me back to jail. Now, a lot of you will have a question. What happens to the 3 years? Well, the state is immune. You can't file a compensation against the state. And this is the fragile state of the criminal justice system in the country. Okay? This is the fragile state of the criminal justice system in the country. So, this is what is called the principle of double jeopardy. Then you have something called the right against self-incrimination. Article 20, Clause 3. The right against self-incrimination. The right against self-incrimination, which means you can't be forced to give any statement or any evidence against yourself. Even the US Constitution also recognizes this right, by the way. This is called, I'm exercising my Fifth Amendment and so on and so forth. Anyways, so I'll give you a simple example, a real example. Some of you may be aware of the Arushi Talwar murder case. The Arushi Talwar murder case. It was one of India's most celebrated criminal trials. Okay, it was one of India's most celebrated criminal trials. Unfortunately, so, and we made a huge spectacle about it in the media, and we as a nation must be ashamed of ourselves for doing so. The broad facts of the Arushi Talwar case, for those of you who may not remember, are a very simple one. The broad facts are, Arushi Talwar was the daughter of a dentist couple based out of Noida. She was found dead under mysterious circumstances in her own home. Okay, in her own home. Right? Now, the case went up. The CBI was also authorized to conduct an inquiry in this matter, and the CBI started with their proceedings. One of the key suspects in this case, of course, were the parents, and the other was the servant or the domestic help, and the friends of the servants or the domestic help. Now, in a situation like this, in a circumstance like this, what the CBI had done was, CBI had injected a truth serum. This is a common name, a colloquial name of a chemical or a drug which makes a person in a slightly drugged state, and apparently you're only supposed to say things which actually happened. And they recorded, they interrogated this domestic help and asked questions on the basis of the truth serum test. This is also called narco analysis. This is also called narco analysis. But what you did was, you forced the servant or you forced the domestic help, and I hate using the word servant, it should always be domestic help. There's always dignity to the labor. Anyways, so you forced the domestic help to say something which the person did not want to, and this is against the right against self-incrimination. Incriminate means to say something against yourself, and you have the right to not do that. This is also why any statement which is given before the police is never considered final and binding. The court always asks the person, do you agree with this statement? Was this statement given to you, or did you give the statement under some force, under some coercion, under some stress from the government, and so on and so forth. Okay, understood this? Are we clear on this? Right? So that is how it works. Right? Now, in the seatbelt case, if the person was not wearing a seatbelt because the seatbelt was broken, then you'll have a all-day challan. But if you're not wearing a seatbelt and the seatbelt is perfectly working, then you will only get a challan for that very specific incident. Okay? Do we understand this? Is this absolutely clear? Okay? Sure? Yes? Alright, so these are the three basic rights which are available under Article 20. Very general rights, rights which specifically lead to self-incrimination. Double jeopardy is you can't be tried for the same crime twice. Okay? You can't be tried for the same crime twice. Alright. Now we look at Article 22. Alright. Article 22 are about certain protections that you would have with respect to arrest and preventive detention. Very legal in nature, the exam barely asks you these kind of questions. Anyways, this is very political in nature, so you'll see this in a lot in current affairs, but this is too controversial to be asked in the exam. A lot of your UAPA, a lot of your contemporary laws are related to preventive detention. Okay? All right, Atul. Yes, it is. Now, let's continue. No, narco analysis has been declared unconstitutional by the Supreme Court. You can't conduct narco analysis anymore. You absolutely can't conduct narco analysis anymore. Okay? Understood this? All right. Okay. Let's start. Article 22. Protection against arrest and detention in certain cases. First, this is a very technical article and half of the article has not even been enforced yet. Okay. So your first clause is, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, and nor shall be denied the right to consult and be defended by a legal practitioner. मतलब वही बात हो गई, okay? Because you would have committed a crime on the other hand, no Himanshu? That is why. Arushi Talwar case, Supreme Court. So the court, I think, had acquitted the parents. They were originally charged. Nobody still knows who had committed the crime, right? Okay. So Article 22, Clause 1. Now in Article 22, Clause 1, it says that if the police arrests you, then they have to inform you as to why they are arresting you. They have to inform you the reasons for your arrest. You also have the right to inform your guardians, your next of kin, and you also have the right to a lawyer. This is basic principles of natural justice under a free and a fair trial. अब अरेस्ट कर रहे हैं तो बताना तो पड़ेगा ना क्यों कर रहे हैं. Remember, arrest means you've been arrested after the police thinks you may have committed an incident or you may have a role to play in that specific incident. Okay, you may have a role to play in that specific incident. Okay, all right. Now let's look at Article 22, Clause 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. I have discussed this with you already. Any more technical detail is not needed. And this 24 hours does not include the time necessary for the journey from the place of arrest to the court of the magistrate, and no person shall be detained in custody beyond the said period without the authority of a judicial magistrate, right? Now, or a magistrate. Now, the provision does not specifically mention judicial magistrate because in most parts of the country, there have been several issues of the lack of people filling up lower judicial vacancies, which is why a lot of times you guys have to double up as executive magistrates because judicial magistrates are not available, you know, in remote areas or remote subdivisions for that matter. Okay, this is also a major problem in the country these days. Now, 24 घंटे में लेके जाएंगे, time of travel, government holidays, ये सब count नहीं होगा, which is why a lot of high profile arrests usually happen on a Friday evening. Okay, now we've discussed this in citizenship. Nothing in these clauses shall apply to any person, clauses 1 or 2 shall apply to any person who for the time being is an enemy alien. Remember we studied enemy alien, who are basically citizens from a country that we have officially declared as an enemy territory. So that is it. I just gave you the explanation between arrest and detention. Legally there are a lot of differences, but for you as general studies students, arrest is after the incident and detention we will generally refer to preventive detention. Otherwise there is something called punitive detention, which is also called arrest. There is remand, there is custody. ये सब आपके सिलेबस में नहीं है, यहाँ सर फोड़ने की कोई ज़रूरत नहीं है, ठीक है? All right. So will not apply to an enemy alien, and this will also not apply to any person who's been arrested under any law providing preventive detention, right? So enemy aliens के लिए नहीं लगेगा, which means enemy aliens के लिए कोई ज़रूरी नहीं है 24 घंटे मैजिस्ट्रेट के सामने लेके जाने के लिए, या enemy aliens के लिए कोई ज़रूरी नहीं है that they have the right to a lawyer, they have the right to be informed, ऐसा कुछ नहीं, because you might be compromising the security of the country, or you have been detained under a law which gives the powers to the police to arrest you thinking that you might commit a crime, कि तुम शरारत करोगे इससे पहले ही तुमको हम अरेस्ट करके रख लेते हैं कुछ दिन के लिए. And there are several preventive detention laws across the board. राइट. नाउ एनीथिंग बियॉन्ड दिस, बाय द वे, इसके बाद का जितना ड्रामा है, जितना ड्रामा है, ये सब कुछ, ठीक है, ये सब कुछ अभी इन्फोर्स ही नहीं हुआ है. ऑल ऑफ दिस हैज़ नॉट बीन इन्फोर्स्ड. इसको पढ़ने की कोई ज़रूरत नहीं है. I will give you a little bit of understanding on preventive detentions right now, and I have a discourse prepared for it. But ये सब पढ़ने की कोई ज़रूरत नहीं है. ये सब कोई कुछ नहीं पूछता. ये अभी implement ही नहीं हुआ है. ठीक है, ये सब कुछ भी implement नहीं हुआ है. Then of course you have to inform the person in case of preventive detention that you can question the order, basic principles of natural justice, and if you have been detained which is in public interest, then it's not necessary to disclose the reason for it. इसके बाद वाला फिर से कुछ भी इम्प्लीमेंट नहीं हुआ है. ये सब रहने दिया गया, ये सब नोटिफाइड नहीं है. देख लो, डेट टू बी नोटिफाइड, डेट टू बी नोटिफाइड. बट वी मस्ट स्पेंड सम टाइम ऑन प्रिवेंटिव डिटेंशन. बेसिक है. What is the basic difference between arrest and preventive detention? Arrest is arresting after on suspicion that you may have committed a crime. Preventive detention is on suspicion that you may commit a crime. In arrest, you get the right to a lawyer, you get the right to be informed. In preventive detention, you get the right to be informed, you get the right to question your preventive detention, but you don't get the right to a lawyer. ये बहुत बेसिक डिफरेंस है दोनों में, और कुछ नहीं है. इसके ऊपर की टेक्निकल डिटेल्स आपके सिलेबस में नहीं है, आपको पढ़ने की कोई ज़रूरत नहीं. आप पढ़ना चाहते हैं तो आप पढ़ लीजिए, बट आपके लिए एग्जाम में कोई काम नहीं आएगा. नाउ लेट अस स्पेंड सम टाइम अंडरस्टैंडिंग preventive detention. What is the history of preventive detention in the country? Why do we talk about it? What has happened in the country in the context of preventive detention? And this is very, very interesting. This is very, very nice to understand things in a larger context. ठीक है, मतलब ये बहुत इंटरेस्टिंग है बिकॉज ये बहुत पॉलिटिकली मोटिवेटेड है. सो ध्यान से सुनिएगा. लेट्स अंडरस्टैंड दिस इन द कॉन्टेक्स्ट. ठीक है. नाउ the philosophical basis or the rationale behind preventive detention is largely to safeguard the interest of the country. So preventive detention, as much as it has a legal implication, it also has what is called an ethical implication, because on one hand you have to balance the security of the state, law and order and peace in society, and on the other hand you are compromising the life and liberty of a person by detaining them for something that they may do. A crime has not been committed yet. Okay, so that's something we must understand, right? Now this is something that was done excessively in the British rule, and for a colonial power it seems to still be justified. It still seems to be a reason why they would want to do it, but today it is also still used in democratic regimes. In India, the world today, in India today, caste and communal clashes have really become a reality of the country, and which is why there have sometimes been there have sometimes been necessary reasons or a justified reason to set up what is called a preventive detention law. Okay. So as I was telling you, preventive detention is nothing but when a person is held in police custody on the basis of a suspicion that they may conduct a crime or they may harm public or society in general. Okay. See, you must understand, the police generally have these powers to arrest somebody on suspicion under CRPC, but you also have specific preventive detention laws, right? Now the police do also have additional powers to make such kind of arrests without a warrant or without adequate permission in a very select number of cases, as I mentioned, in CRPC. Now see, you must understand, there are technically two kinds of detention. One is called punitive and one is called preventive. What we are referring to is called a preventive detention. Now let's understand the basic difference. So a punitive detention is you're detaining somebody as a punishment for a crime. This is usually how custody and arrests work. But preventive detention is also often called administrative detention, wherein where the person who's directing your detention is the executive, is an authority, and the decision lies entirely within the executive. Your punitive detention or your arrest is granted to you by the court, but your preventive detention is granted by the executive itself, right? Now, basic provision that I was telling you, section 151 of the CRPC does give you these kind of provisions. Now let's understand this. Historically speaking, I don't know if your modern history teachers have covered this for you or not, but especially during the World Wars 1 and 2, if I remember correctly, especially during World Wars 1 and 2, England had created some very special kind of laws. They were called Emergency Powers Act or the Realm Act. These were essentially preventive detention laws, right? This Defence Act was then later on replaced by the Rowlatt Act of 1919 and the Bengal Criminal Ordinance of after the World War One. Both of these were basically giving powers to the government to arrest anybody on the suspicion that they would be committing, they may commit a crime against the British government. So when you studied Rowlatt Act, and now the next time you study Rowlatt Act, you'll understand that this has something to do with preventive detention, right? Now, very interestingly, in India, the first Preventive Detention Act was passed within the first year of the Constitution in force, right? And this was essentially this is basically giving the powers to the government to detain somebody on the basis of a suspicion. ये 1950 में एकदम नए नए साल में. And remember, we were talking about A.K. Gopalan, the A.K. Gopalan case with respect to Menka Gandhi. It was A.K. Gopalan, which in this the validity of this preventive detention law was challenged, but the Supreme Court said that the act was constitutionally valid and the government is justified in doing so, and इसमें आपका कोई privacy वगैरह जाता नहीं है, ठीक है. Now there are, so I was telling you, there were several anti-defection laws. If you want a little bit of history, I'll tell you. The first one was in 1950, and this was called the Preventive Detention Act. This was supposed to be there only for 2 years or 3 years, given the context of the partition and several anti-state elements, but it continued till about 1971. Then in 1971, when this act ended, the Maintenance of Internal Securities Act was passed. This was essentially also empowering the government to detain somebody without a trial or to preventively detain somebody, because it was also used as a tool politically to put anybody who challenged the Congress behind bars, and your Advani and your Vajpayee and your Mulayam Singh Yadav, Nitish Kumar, this Lalu Prasad Yadav, Ram Vilas Paswan, all of these four are the birth of these four socialist era leaders comes from the Maintenance of Internal Security Act, right? Now this act continued to be in operation till about 1977. Once the Janata Party came to power, there were several amendments made in the middle, but this was there. Then in 1977, India finally was reaching a point where we were not supposed to have any, preventive detention law. Then you had a law called Coffee Posa in 1974. This was basically like a backup or like a backdoor act to MISA. कॉफ़ी पोसा का आपको फुल फॉर्म करने की ज़रूरत नहीं है. What it basically meant was Foreign Exchange Prevention of Smuggling Act. इसमें भी you could be detained preventively if the government thought you were performing any illegal trade as such. Okay, ये लॉ चलता रहा 1984 तक. फिर 1985 में टाडा आया. टाडा आप लोगों ने सुना होगा, द टेररिस्ट एंड डिस्ट्रप्टिव एक्टिविटीज़ प्रिवेंशन एक्ट. This act was brought into place, especially in the context of the Khalistan separatist movement. Again, this was supposed to be a temporary law for 2-3 years, but was reintroduced in 1987, continued to be one of India's most powerful preventive detention kind of laws. ठीक है. This law continued, I think, till about the 90s, and then was replaced by late 90s, and then was replaced by the Prevention of Terrorism Act of 2002. This was in, and this is very interesting. We passed the Prevention of Terrorism Act in 2002 in the context of the 9/11 attacks that happened in the US in 2001. This was essentially done also in the context of the parliamentary attacks that happened in India in December 2001, where we were able to, kill almost everybody, killed everybody who tried to attack the parliament. This act continued to be in existence till I think 2004, 2005, right? So ये रहा है. और इसमें एक बैकग्राउंड लॉ है जिसको हम कहते हैं अनलॉफुल एक्टिविटीज प्रिवेंशन एक्ट, यूएपीए. Was first enacted in 1967. This was essentially again to combat separatism. Then this act also gave powers to the government to declare a lot of the organizations in the country invalid or ban a lot of these, right? This was done again in the context of the demolition of the Babri Masjid, or the rise of separatist movements in Kashmir. The UPA government amended the UAPA Act in 2004, and then gave more powers to itself. And then this act was again highlighted in the news around the Bombay attacks of 2008. Now, here, maximum period of police arrest, warrantless arrest, restrictions on bails, all of these were included, and it was made a very, very strong legislation. Then 2012, it also included an amendment where anybody in the business of fake currencies would also be preventively detained. And then, of course, the latest amendment was in 2019, where the National Investigation Authority now has the power to even put individuals, not just organizations, as under preventive detention or under surveillance on grounds of act of what is called terrorism, and so on and so forth. So this is the broad history of this. This has largely been how preventive detention has worked in the country. ये बहुत political है, एग्जाम में negligible आता है, but the point I wanted to just get across with you was that most of our preventive detention laws have evolved with respect to certain events, from partition to communalism to caste violence to Khalistan to 9/11 to parliamentary attacks to Babri Masjid demolition to other Gujarat riots and counterfeit currencies and so on and so forth. Okay, right? हाँ नितिन, ऑब्वियसली इन्फानाइट के लिए नहीं कर सकते, वो सुप्रीम कोर्ट बोलता रहता है. यस, ठीक है, डन. So this takes care of your Article 20 and 22. I don't need you to do anything else beyond this as far as the exam is concerned. This will take care of most of it. ठीक है? Understood this? All right? Done. See you tomorrow for 23, 24 and we'll look at certain correlative examples. Thank you.